Chief Justice Roxanne George Wiltshire says her office has no authority to nullify the vote cast by the former MP Charan Das Prasad. She stated that before any court can treat with any issue or matter, it must first have the authority or jurisdiction to do so. The Chief Justice noted that in the context of the case, an applicant cannot be complicit in a situation of determining a legal vote. The Chief Justice stated that the Constitution clearly outlined its position on the legality of the vote and opined that if the vote was done in the opposite, there would not have been court proceedings. The Chief Justice noted that the provision in the Constitution of Article 156(1) is different to that of the Constitution in Section 41D. She drew reference to several other court proceedings which varied in rulings.
But in my view, one would not be able to choose an issue such as, for example, a no-confidence motion to say that a vote on that issue that one was displeased with becomes a nullity because of the serious consequences for the government of the day, while other matters, including national budgets on which an unqualified member voted, would remain intact. To my mind, this is to approbate and reprobate. While I agree that continued illegality should not be permitted, whatever was done, a vote of an unqualified MP cannot and would not nullify that which has occurred in the past where the proceedings were lawful.
The government in their submission had asked the court to decide on the dual citizenship issue, but the proceedings were filed incorrectly. Even though the Attorney General Basil Williams cited that it was a breach of the Constitution, the Chief Justice cited that the AG should have filed proceedings under the National Assembly Validity of Elections Act.
A party cannot be complicit in the perpetuation of an illegality and cry foul when things go wrong. Indeed, as was pointed out by both Mr. Datadin and Mr. Nandalal, if the second respondent had voted against the no-confidence motion, there would no doubt have been no contestation or protestation, and Reid, the Attorney General, and Mr. Harmon would have counted his vote as valid.
The Chief Justice further ruled that even if the current administration had used the right method of actions by law, the time prescribed by the Constitution to file such proceedings had expired. Chief Justice George Wiltshire said that Prasad should not have been a parliamentarian. She said a ruling on this could have an adverse effect on all previous votes cast by the former MP.
The effect of these declarations is that anyone who holds dual citizenship as defined within the parameters of Article 155(1)(a), as discussed above, cannot lawfully be nominated or elected as an MP. The declarations sought in paragraphs 4 and 7 are refused for the reasons given, while raising important points of constitutional law for clarification. The other declarations sought at paragraphs 3, 5, 6, and 7 cannot be granted as on the ground of lack of jurisdiction for the reasons outlined, though I have concluded by way of comment that these declarations could not or would not have been granted in any event, as the no-confidence motion was saved by Article 165(2).
She suggested that parliamentarians with dual citizenship should resign with immediate effect due to the fact that it is unconstitutional. Javon Vickery, HGP Nightly News.